So a lot of times people will come into my office and they'll tell me they want a will or they want a trust, and they maybe don't understand what the difference is between the two. So I'm going to tell you a little bit about how the two vary. And oftentimes when I work with a client, I end up giving them both. So really a will is something that you traditionally hear about. People will write a will, and that will state that when they pass away, they're going to give their stuff or their assets to their spouse or to their child. The will have no effect at all while they're alive, and it will essentially jump into effect when they pass away. A will then be read by a judge in a probate court, and that judge will make sure that all those things happen once you're gone. Nice and simple. In many states, that's enough, and people will be happy with the result of just having a will. Unfortunately, in California, that's really not the best way to go. In California, what we often recommend is a trust. A trust is a separate vehicle or a separate entity that people will put together during their lifetime, and they'll put their stuff into that trust, and they'll manage it while they're alive, and then it'll make sure that when they're then gone, somebody else will take care of that entity and pass their assets. It's really nice because you can avoid court, make things faster, make things less costly for your loved ones. We still do a will, so we do both of them, and then together they'll just make sure that your stuff goes where you want it to as quickly and as easily as possible. So we'll do both here in California for most people.